All right, everybody. Welcome to the Creative Finance Collective. We meet every Tuesday at 2:00 p.m. Arizona time. We're here to talk about creative financing. So if you have questions, we're here to answer those questions. Post them in the chat. We'll get to them throughout the episode. I know we got a couple folks that we're trying to get on and struggling, so we may have a few more here. But again, we're taking questions. So if you're watching and you've come to the table with questions about creative financing, now is the time to ask away, and we will get to them. Scott, how you been?
Crazy, my friend, crazy.
So I understand it's your birthday today.
How did you know that?
Well, I mean, other than it's blasted all over Facebook to the entire world, I had heard that that today's the day. What you got, big plans or what?
I am in beautiful San Antonio opening the title office down here today.
Oh,
So
okay.
they make me work on my birthday. Can you believe that?
Jeez, I don't know who this they is, but they sound terrible.
They are. I'm pointing at one right over here who's down here with me.
So yeah, so
By the way, I'm assuming that the gift's in the mail, right?
it is.
Okay.
Well, given that it's your birthday, we'll let you start off. There was this video that I came across, and I couldn't help but think of you and what comment you might have about it. So we'll let you kick it off here. But let me share this.
I'm just going to love you on this one, whatever it is, I'm sure.
Yeah. No. Yeah. So I found this, and was this in celebration of a birthday or what? What's going on here?
This is what you call don't take your entire office gambling. This is what they make you do on the bus.
This isn't the birthday trip to San Antonio or anything?
No, unfortunately.
Because
we lawyers are supposed to be a little more, reserved, right?
Yeah.
Yeah, those were $100 bills they were putting in there, and after I got a chance to keep any of those.
Yeah, they took them out at the end, and I thought you didn't at least get to keep them.
And it was just, anyway, they're not fair.
No.
It's
I keep getting the references to they and them. They sound like a ragtag crew of taskmasters.
Oh, they're horrible.
Yeah.
But they are. But thank you for bringing that back up to me. I'm trying to forget all that.
Well, that
was even done sober, so the things they make you do.
Yeah. So yeah.
And Andy, we may have to find something on you out there too.
Well, there's plenty. Yeah. Look, I even got a question out of this. Is Scott single? They want to know.
Depends on who's asking.
Yeah. Oh.
Don't y'all remember there was something? I remember this from 100 years ago. If y'all remember tennis players, Steffi Graf at all.
Oh yeah.
And what was the guy?
Andre Agassi.
Yes.
Yeah.
There he is. And I know they got married. They're still married actually, which is great. But she was in some final somewhere, and some guy yelled at the stand, "Stephanie, marry me." And what was her reply? "Well, how much money have you got?"
Yeah.
I always have a problem with that one. I never got lucky enough to marry wealthy. I always had to work my tail off.
We got another question. Can we resell transfer to another buyer? I don't know if they're talking about your video or a property doing subto.
We can license anything out, I don't think that's something you make a lot of money off of, unfortunately. It's not worth doing.
Yeah.
So what is the question? Can you buy a property?
Yeah, so we do have another question here. So if you're just now joining us, this is not just a spoof on Scott's birthday, but we are taking creative finance questions. So post them in the chat. We'd love to get to them. We got an interesting. Can I buy a property subto from a successor trustee of a deceased homeowner without the permission of the beneficiaries? What do you guys think?
I'm trying to figure out the question first. I'm going to make the assumption, and Sean, you can kick in here too, but I'm guessing they have this property in some kind of a trust.
That's what I'm assuming, that yes, that the
And
property's owned by a trust.
so
And
there's a successor trustee who would be a proper trustee in writing. Let's assume that, right?
yeah,
Yeah.
I think we can.
Without permission of the beneficiaries.
Yeah, so the beneficiaries know or don't know, have said or have not said anything one way or the other about it. That can the trustee just do it?
Well, Sean, you're our trust expert, my friend. I know my answer, but
So, I mean, unless there's some prohibition in the trust, then the successor trustee has full power to convey the property and you don't need the approval of the beneficiaries. So from a buyer's perspective, assuming, once again, that there's no prohibition in the trust, then the successor trustee can convey it, and convey good title. One consideration, if you're representing the trustee, is, do you, as far as being a prudent investor, a prudent fiduciary, do you want the beneficiary's approval before you engage in that transaction? But from a buyer's perspective, that's not a requirement. Scott, what do you think?
well, I think your answer is right on, but I'd still want the beneficiary's permission to do so. I can't imagine the lawsuit if the trustee that's on their volition decided to sell the property out from underneath the beneficiaries without their permission or direction or things of that nature. And what type of a lawsuit could follow on that? I just don't want to get entangled into it.
Right. That's
I
exactly.
think it's just being smart.
Yep.
Yeah, doesn't it? Wouldn't it essentially come down to? Oh, we got Alan. Hey, Alan, how you doing?
Doing well. How are y'all?
Good, good. We're addressing the question: can I buy a property subto from a successor trustee of a deceased homeowner without the permission of the beneficiary? So the property's in trust. Trustee is in place, or a successor trustee is in place. They want to know if they can buy without. We don't know whether the beneficiaries have said no one way or the other. And the one thing I was going to add is it becomes more of an issue about whether the trustee has maybe properly managed or put the assets to best use on behalf of the beneficiaries. It's not to say that the best use maybe couldn't be to sell it subto. But if you're a beneficiary and you're like, well, you could have liquidated this thing for cash and just distributed that accordingly, wouldn't that make more sense? But Alan, what are your thoughts on that?
Well, so if it's a real trust versus a land trust, then it's a different story. Land trust, we want beneficiaries to sign off on everything. But if it's a real trust and it's drafted correctly, then I'm talking about underwriters now. Underwriters aren't going to necessarily require that beneficiary. With all of our wrap trusts, we're including beneficiary signing off.
Okay. So it sounds like either way you want beneficiaries signing off.
Yeah, especially since it doesn't hurt.
Well, they have common sense down in Austin even, so I like that too.
It trickled down.
Well, I'm trying to recall, I think generally speaking, if you looked at a trust document, this goes to Sean's earlier point, a trustee is going to have pretty broad, extensive power about what they can do with the asset. Alan, I don't recall, but in a land trust, are the powers granted to the trustee typically less so than like in an estate planning revocable living trust?
Yeah. I mean, a lot. Well, I say a lot less, but
Yes, it depends on the trust, each individual trust.
and the underwriters are smart. They're looking at this thing going, okay, the beneficiaries are controlling this. The beneficiary is the investor. The beneficiary is calling the shots. We no longer even like the trustee. We like the beneficiary signing off. So they're smart.
Yeah. Makes sense. All right, if you're just now joining us, this is the Creative Finance Collective. So we're going to be on as long as we get questions. If we don't get questions, then we all move on with our day. So we'll wait and see if we get any more questions here in the next few minutes. Are any of you guys NFL football fans? Because that season's about to start, or is everybody in on just college football?
I can't spell football.
Okay.
So
Is that an Austin thing too?
I don't watch it no more.
No.
I
That sounds
like
like
college. I don't like the portal. I don't like it's all about the money today. Pro kind of lost me of all the crap from a few years ago, but I will watch it. But do I watch it like I used to? Not at all. You know, same way with basketball, college b-ball, especially March Madness is fun when it's true, gamesmanship going on out there. But college football is fun. I don't like it when my Aggies lost to Notre Dame, though, last Saturday, but okay, one of those things. Into every life, a little rain must fall.
Yeah.
Hey, I did have another. I'm trying to keep y'all up to date. Had another home loan serve due on sale issue, and then had a second one where we put the trust in place. Now it was a post-close trust, so we're playing with them a little bit, and they came back and said our borrower is not an additional insured; it's an additional interest, and so we need to see your trust documents. So we'll send those up, but they're still messing with us for some reason.
Well, Alan, when I go through those hoops like you just did in that regard, and I get the insurance, I always make certain that the trust is drafted in a way that when you forward that trust to the lender, it's going to pass muster. That's where Alan may or may not have an issue with that a little bit. Not Alan, Sean might. But it's that. But when you draft that insurance policy, that prior homeowner still needs to be listed as a co-insured, additional insured on that policy along with their trust.
Yeah. And
I think so often these guys they miss things along the way out there that create problems for themselves.
The average bear doesn't know how to do it. The average insurance guy doesn't know how to do it. And it was funny. We had two referral resources for us, and one of them said they weren't going to be able to put additional insured, put the borrower as additional insured. And I said, I like you a lot, but we're not going to be able to use you. And I guess he thought I was joking because he kind of scurried off, and I referred everything out to resource number 1 and 2 and not him. And then he calls me and says, hey, we're going to be able to put those borrowers in as additional insureds, Alan. I said, well, good. We figured that out.
Yeah. Next time around, we'll take care of you. Right.
Yeah. And so it's good. I like having 3 resources, but the thing I'm doing with the trust. So, and I don't know if it's the same out there in Arizona, what have you, but all we're required by statute is to show the certificate of trust. And so on that certificate of trust, I have the borrowers as the trustee, and we don't say who the beneficiaries are. And Sean, as you and I discussed, we want the buyer investor to be the settler, grantor, creator, what have you. So I don't know if that's going to cause some type of problem since their name's on there. That's what I'm messing with right now, getting ready to send that certificate of trust up to home loan.
Well, I think, Alan, I'll let Sean follow up. He's our whiz kid on this stuff, but I think it's going to depend on, you send them the certificate of trust, and will that satisfy them or not? Or they want to see the actual trust document or not?
So I'm gonna kick back if they say I want to see your trust documents, because the whole thing about a trust, well, part of the benefit of a trust is the anonymity and the protecting of potential minors, things of that nature, estate planning. So I'm gonna buck pretty good on that. The first trust we sent up was back when we were putting the seller as the creator, grantor of the trust. So this will be my first one where we have the buyer listed as the grantor creator.
Yeah. Well, I get that's what Sean preaches, and like you, I need to spend 30 minutes with Sean, let him educate me more so in this regard, because I'm not a trust attorney at all, and Sean sure does sound like he's pretty good at it. But I think it all boils down to what that lender is going to ask for and what they want to see. And I like the pushback, which I like pushing back just as well in that regard. I think it's a great thing to do in that scenario. And it's just going to be, is that going to be something that's going to be acceptable to them or not?
Yeah, I guess we'll put the statute in our little letter that we send up to them. Here's what you can ask for. You can ask for my certificate of trust. You can't ask for more. So we'll see. I'll keep you updated.
Well, Alan, has it been a practice for lenders to demand the entire trust? I've usually, when I've dealt with third parties, they don't even want like if you sent them the full trust, they'd be like, what is this? I want a certificate, because they're so used to dealing with that. And the law, and I'm sure in Texas it's probably similar. The law here in Arizona, says a third party has the right to rely on that, that certificate is pretty much, you can bet that it's, or you're allowed to rely on it.
Yeah. The first one went by extremely smoothly. They received it. We even got a correspondence back that said, okay, we're good.
Okay.
And I did notice another one.
Streets for your birthday.
The lender was asking for proof in the LLC documents that their borrower was a part of the LLC. So that's not one of the exceptions, but they were treating it as if it was. So I thought that was interesting.
I think if you were to, I really think, Alan, that if our clients would get their insurance drafted properly, where the trust becomes the primary insured and the prior owner becomes, of course, the additional insured with the right company in that regard, and you provide them that certificate of trust, I really think they're more concerned about the insurance being handled properly than it is who per se is in the trust. Now, it doesn't mean that they're not getting more wise to some of these kind of maneuvers and whatnot, but I just don't think they care that much about the trust of those things. If the loan is current, the insurance is good and valid for them, I think those are the primary hurdles that lenders are going to look at. I think that the trust issue almost becomes secondary.
Yeah, I agree. On the typical situation, we have one where the seller refused to leave, and so there's litigation going on with that. And then the lender came in and said, "Hey, y'all have wrapped my note. Need to undo that." And so obviously we're not doing any kind of deed flip flop, what have you. The buyer ended up filing suit to quiet title, get a TRO. But I tried to take advantage of this and ask one of the mortgage company attorneys. I said, why do y'all care that it's sold? And he said, it's a breach of the due on sale clause. I said, no, I got that. So now you've got two people who are liable for paying your mortgage. From a business standpoint, why does your client care? And I could never get the answer from the guy. He just kept saying it's a breach of the due on sale clause.
They're going to stick to their guns, read their script every time because they do not have a better answer. Their client is still liable on the debt. They're still in first lien position. I love Arizona's statutory requirements that if they're not harmed per se, and or maybe even improved, they can't even call the due on sale. We need to transplant that back into Texas, I think. But the lenders will never have an answer. My gosh, guys, I debated a lawyer one time on this, and they had sold the property to a 75-year-old couple, or maybe 78 years old. And they moved into a nursing home shortly thereafter. And this went back around about everything from due on sale to elder law to this to that, you name it. And you could not get a direct answer out of them to save your life. My fun story is the very first due on sale I even dealt with was on me personally, where I had bought a property back in, gosh, probably
Late
2000,
1800s.
2001. I had closed
On
it
the
through
turn
a
of the
company at that
century.
time called World Savings. And we had probably done 50 loans with them at one time, refinances. And in 2010 or 2011, we had a 10, 12-year excellent pay history on this thing. We were at probably a 50% loan to value or better, maybe 40%. And I get this call from this little young lawyer out of Dallas representing Wells Fargo, because World Savings sold to somebody who was taken over by Wells Fargo or this or that. And somehow my loan wound up at Wells Fargo. Of course, I got zero notice of that loan ever being transferred to Wells Fargo. Along the way, this poor little girl calls. I get this due on sale letter, and I call her up, and it's like, what the heck it's like, how many loans does Wells Fargo today have in default, an active default? And I bet you it was hundreds of thousands, right? Just after the crash of 2008, 2009. And I blew up at her. I was just like, what are y'all doing? You're taking a fully performing loan. Everything's done just right, that you took over from a lender that had actually approved all of this. And now you're calling it due. And of course, she had zero answer. Almost forced her to tears, I think. And I wanted to call my state senator at that time and going, what the hell are these lenders doing out there in the marketplace, calling fully performing loans due when, on the other hand, they have hundreds of thousands of loans in default they're doing nothing with right now. And it's just, you just get crickets, unfortunately, when you bring those kind of things up. There's never going to be a good answer, I don't think, out there.
Yeah.
So I have a world savings story for you.
Are you as old as I am, Sean?
Yeah, no.
Thank you,
But
Sean.
you dance better than me, so.
Yeah.
What can I do? So World Savings actually went to Wachovia and then went to Wells Fargo. But when I was in college, I was a teller at World Savings for probably 3 or 4 years. And in that process, I actually had the privilege of being in a full-on takeover bank robbery, where they came in with masks and guns and put everyone on the ground and basically took over the branch for a good, it was only a couple of minutes, but in any event, so that's my World Savings.
Did you just go take whatever, take their money, can have all of it?
Oh, yeah. I got down pretty well. I was actually, long story short, but yeah, I was like one of the last ones on the ground. Yeah, everyone was on the ground, and they went through and took the money themselves out of the drawers and whatnot. Ended up with a bunch of die packs and bait money in the process. I don't think they even got all that much, but they were in and out, 2 minutes. They were quick. But
wow.
So yeah, that's my World Savings story. So
do you want to go through that again?
Finance, but
Do you want to go through that again?
Do I? Well, I kept working there. In fact, our branch, we had a security guard at the time because our branch kept getting robbed. But it was like just one person, one dude showing up, showing a note, then maybe showing a gun. One guy claimed to leave a bomb, and we had to evacuate. But basically our security guard was there, like letting the, customers in and opening the door for them and whatever. And these guys just pulled up with a minivan, threw the door open, had a gun on him, and took him in and threw him in the middle of the branch. But because our bank was robbed so often, myself and another teller, we became known as like the go-to guys to reopen our branches after robberies. So like whenever there was a robbery, we'd travel around Southern California and go and reopen the branch for them and work the branch because they were all traumatized and, had to go home for multiple days and whatever. So, so I kept working there even after the robbery, but in any event,
They give you hazard pay or not?
I think they bought us dinner or something like that while we're reopening. They didn't give us any hazard pay, man.
Yeah.
Not happening.
Congratulations, everybody. You didn't get shot. We're going to take you to dinner.
Yeah, exactly.
See, this was your chance to embellish and tell the world that you roundhouse kicked the bank robber's gun and saved the entire town of Sacramento.
He didn't pull a Schwarzenegger or a Bruce Willis or whatever it might be out there,
No. Although it's probably good it happened way back then when he was young. Nowadays, old and cranky, you pull that kind of thing, that robber might be in for it. All right, we do have a question. If you're just now joining us, this is the Creative Finance Collective. We do talk about creative finance and creative financing. If you have a question, make sure to post it. We'll be on here as long as we're getting questions. Let me read it. It says, I'm wanting to buy a property in Arizona that is in probate and being foreclosed on. Home has several liens Home has several liens on it and 2 different auction dates. I want to buy the home. What do I watch out for?
John, Andy, it's your backyard.
Yeah. Well, you run a title report, right? That's the first thing you do is figure out what else there is and what else. I mean, apparently they know that there's some liens, right? The question is, are there other liens? Where there's multiple liens, there's oftentimes more.
Well, I got 2 first questions, Andy. My first question is they say it's in probate. Is there an actual filed probate where the will was filed? There's actually an executor appointed?
Right.
That's my first question I'd always ask people like this because you don't know that answer. And the second thing is how are they trying to buy the property? Subject to the debt? Are they paying cash or what are they doing?
Sure. Yeah. Sometimes the other good reason why it's worth asking or delving into the probate question is if, like you said, Scott, if there's an open probate, that would tell me that here in Arizona, it's called a personal representative. Somewhere else might be called an executor, but that they've looked at this, and it's not uncommon in when dealing with estates that a PR or executor, trustee, whatever the case may be, looks at the property and looks at what's its encumbrances, so on and so forth, and just sees that it's not worth it or it's not of value to the estate, because the estate doesn't care if there's a foreclosure and it's going to hurt unless there's like extended liability because of a deficiency or something else. But if it's just going to be a foreclosure, the state doesn't care about credit history. They're just going to do what makes the most sense for the estate, and sometimes that's letting a property go. So that go ahead.
No, I was just training the girls up here today on a subject to where the investor is buying the property from an heir or from heirs, and talking to them about liability. It's like, guys, there's not liability. This is why we want to do this the right way, because if a investor buys properties from the heirs don't have any liability on the underlying debt at all. No one does. They're done and gone. So from the estate's perspective, if there's an executor already appointed, then obviously somebody has served the executor already
Yeah.
in order to get good service.
Yeah. Yeah. And I guess I would say too is maybe you've done a title report, but know which lien you're bidding on too, right? If you're bidding, if there's multiple liens, or there are multiple sale dates, if you're bidding on a junior lien, you're going to be buying it subject to a first senior lien. And if your intention was to come out clean and own the property outright, you want to make sure you're bidding on the first position lien, right? And the title report's going to tell you some of that. I don't know that the dates of the foreclosure by themselves would tell you, unless it's the same lender and they've got two liens out and they're listing it for sale. That could be an indication of which one's first and which one's second position. But you want to make sure you know what lien you're bidding on. I think that's the biggest thing. Go ahead, Sean.
So to your point and Scott's point, as far as the estate goes, you have to figure out, does the estate even want to sell the property? If the estate wants to sell the property, then figure out what the transaction terms look like, open escrow, get a title report, and then from there, figure out if it's even doable. You're going to have generally an inspection period or title review period. Figure out if it's doable, and then get payoffs from the lenders that have the foreclosures going. If the estate doesn't want to deal, then you have a couple of options. You could figure out, get a title report, figure out what liens are going to auction. So if, for example, the second position lender, let's say there's two deeds of trust out there, if the second position lender's going to sell, and the numbers make sense, remember the first will remain even upon the closing of the second lender's sale. But if the second lender is going first, you have a higher likelihood of being able to be the winning bidder on that, if it makes sense to be able to just pay off the second position lender's loans. There are, and this is probably true in Texas as well, but there's people in town, lenders in town, who will make loans for purposes of allowing for purchases at these trustee sales. They're very short-term loans, but nevertheless, go buy that second position loan. Then once you now own the property, depending on the date of the first position lender sale, if you now own the property, you can go and statutorily, you have a right to reinstate the first position loan if all that they're foreclosing on is a monetary default and there's no balloon payment, or it's not a reverse mortgage or something like that. You can go and reinstate, and you have a statutory right to get the reinstatement figures and to bring that loan current, and then to continue to pay on that loan and keep it current. So now you basically, by buying the second, you've acquired the property subject to the first, with all statutory rights to continue to keep that first in place and to make those loans, loan payments as to that particular lender. If it's reversed and the first position lender is foreclosing and you have a second position waiting in the wings to foreclose, well, the second position would be stupid to even have started the foreclosure unless they're going to reinstate, because they're just going to get wiped out and they spend a bunch of money. But assuming the first is going to foreclose, you could make a play, and depending on if it's in Fannie Mae, Freddie Mac, or what kind of lender it is, you could make a play to buy the note, call up the trustee and see if it's even a possibility, and then buy the note and complete your own foreclosure. You could even do that with the second. You can buy the note and then pay off the first, reinstate the first, add that to the loan balance. Probably you have to look at the terms of the deed of trust, and then win or place your large credit bid and take the property that way. So there are potential things you can do even without the estate's cooperation to maneuver on this thing. You just got to, right now we're speculating. We don't know, who's foreclosing, what the amounts are, et cetera. The second foreclosure could be an HOA for all we know. We don't know any of that. So, get a title report, see if the estate's going to play ball, make sure if there is an estate that probate is open and a PR has been appointed. But there are things you can do. And, I will tell you, you probably should consult with an attorney in Arizona who can sit down and figure some of this out, especially if you got a title report. In about a half an hour with me or Andy, we could probably have all this figured out, honestly, and kind of give you some ideas and direction. In Arizona, probably same once again in Texas, but all the court proceedings are online. We can figure out exactly what's happening with the estate. We can see a bunch of stuff, deeds and different documents related to the property. We can find the notice of trustee sales. If there's a sheriff's sale, we can find the notice of sheriff's sale. We can find everything we need to basically say, okay, here's your path. Here's what your options are. But I definitely would consult with an attorney and just figure out, what that would look like. But first and foremost, I'd get a title report.
Yeah.
John, answered like a true lawyer.
Well,
I do like what I loved you saying, though, was one of the very first things, as an investor myself, we try to do is it possible to actually acquire one of those liens that may put you in a position to foreclose in that instance, whether it's a senior lien or a junior lien along the way. The question is, can you get a hold of the right people and will they sell it to you? And the answer, of course, is depends. But if you don't make the call, you'll never know.
Yeah. Yeah. I think the lesson here is that where I've seen the biggest failings happen on the foreclosures is when the buyer makes a whole bunch of assumptions just going into it. They don't do due diligence. They saw maybe a quick tutorial on, oh man, you buy something at the trustee sale, all the other liens are wiped out. Never really have an appreciation for priority and knowing which lien you're actually bidding on. Because to Sean's point, it's not to say that if you buy that you should never buy a junior lien. There could be plenty of real estate deals that make total financial sense to buy the second lien, and you might be bidding against fewer people. You just have to know and have run the numbers that it still is worth the deal, knowing you're going to be taking it subject to the senior. But that all comes, like Sean said, with the title report and so on and so forth. All right, guys. Well, that's all of our questions. We're in about 45 minutes or so. So I don't want to, I know you're all busy. Don't want to keep you any longer, but good information, good questions, and try to enjoy the rest of your birthday, Scott.
I'm waiting for Alan to sing happy birthday.
That's probably not going to occur. I'll give you a call after the fact.
As long as it's the singing, cowboy on there, that'd be great. Mr.
Alan, that you calling him after the fact, it might even be worse. Don't do that.
I didn't know it was your birthday, and it took me a little while to log on. I'm wondering what the heck was going on. Is Scott single written as one of the questions?
Listen, I'm not gonna spoil it for you, Alan. But after this, I want you to just go on YouTube and watch the first couple minutes. We gave Scott a little bit of a birthday.
Alan, don't ever take your office to the casino on the party bus.
I just want to be clear. I didn't post anything that Scott didn't already post on Facebook. So
wait, did you say Scott posted?
it was well, whoever maintains the power and control over Scott's Facebook trustee. Yeah,
Trustee.
so
That's a good word for it.
Yeah.
And Alan, see, Andy and Sean already said their gifts are in the mail, so I'm going to make the assumption you're going to put yours in there too, right?
Yeah, no, already.
Okay.
Yeah, he was going to send you a 2% discount to Rapp University.
2%.
I would absolutely love to show up and just sit back and be a fly on the wall and listen.
Yeah.
And Alan goes, heck no.
Now,
Although
I like
Alan, one day
whenever,
that would be fun to have that bantering going on how you do all those kind of things, put it together. You never know.
yeah, no, I like whenever, I look out in the crowd and I realize someone's sitting out there and they've closed, 40, 50, 60 of these deals. It's good. It's good to have people with knowledge out there.
Yeah.
You just don't find too many, unfortunately.
Yeah.
Yeah. Well,
I
good
get it.
stuff, guys. We appreciate you taking the time. We'll see you again next week or when you can make it.
Thanks,
All
guys.
right.
Good,
All
guys.
right.